So today our topic is Civil Procedure Code 1908 for the CS, for the Company Secretaries Executive Students. Let us see what are the important points which are coming under the Civil Procedure Code 1908. So first of all, we have to understand that law is divided into substantive law and procedural law. That means in our country, we are having substantive laws and procedural laws. Substantive law mentions about the rights and the liabilities of the people. If you take the example of Indian Penal Code, what are the offences which are punishable and the ingredients as well as the punishment is mentioned under IPC. So it can be called a substantive law. And procedural law mentions about practices, procedures, and machinery to enforce rights and liabilities. So procedural law is nothing but the steps which we are following in a court of law. That's why it is told that it mentions about the practices, procedures, and machinery to enforce the rights and liabilities. And under CPC, we are having 158 sections from the first part. Another part contains the rules and the orders. Then comes the terminology which is important under CPC. First of all, cause of action is defined. Cause of action is every fact to be proved by the plaintiff to support his right to the judgment. And what is judgment? It is statement of the judge on the grounds of a decree. It is the decision of the court based on rights and the claims of the parties. Then what is this decree? It's a formal expression of adjudication. The conclusive determination of the rights of the parties are done in the form of the decree. And the determination is with regard to the matter of contravention in a suit. And the adjudication should have been given in the suit. And the decree comes into existence on the pronouncement of the judgment based on that decree. And decree is of two types. The first one is the preliminary decree. The preliminary decree mentions about what is to be done by the parties of a case. And final decree is the result achieved by means of the preliminary decree. And the final decree is dependent upon the preliminary decree. And when preliminary decree is set aside, final decree is superseded. Then decree holder is the another word. Decree holder means the person on whose favor a decree is passed by the court or an order capable of being performed is given by the court. The decree holder may not be a party to the suit. Then comes the judgment debtor. The person against whom a decree has been given and an order capable of execution has been given. He is the judgment debtor. And judgment is the statement given by the judge on the basis of a decree or order. An order is the formal expression of any decision of a civil court which is not a decree. An order which is not a final order is called an interlocutory order. An appeal may lie from a preliminary decree also. Every suit is filed in a court of the lowest grade. Under the civil law, we are having a hierarchy of the courts. At the lowest level, we are having the municipal court. Then we are having the subjects on top of it. Then district judge. After that, it is the high courts of the particular states. And the apex court is the Supreme Court. So whenever we are filing a suit, it is filed in a court of the lowest grade. Then comes the word jurisdiction. Jurisdiction is the limit of authority of a civil court. It is just like the range of a mobile tower. Whatever area the civil court is having control, we can call that area as the jurisdiction of that particular court. And the jurisdiction can be over the subject matter, place of suing. That means it is called the territorial jurisdiction. And this territorial jurisdiction is fixed by the government. Then it can be over persons and pecuniary based or based on pecuniary value. So these are the types of jurisdiction. Then depending upon the powers, jurisdiction can be original. Original means the cases are tried and decided, filed before it. And the appellate court hears appeals against decisions or decrees passed by subordinate courts. Criminal and appellate also there. Supreme Court, High Courts and other courts has it. Civil court tries all civil suits unless barred by some legislation like giving power to tribunals in particular matter. If you take the case of company affairs, there is a tribunal which is excluding the jurisdiction of the civil courts. NCLT, National Company Law Tribunal. Then comes the stay of the suit. There is a doctrine of res sub judice, which says that courts of concurrent jurisdiction cannot try the same cases simultaneously. That means during the pendency of a suit, the same suit cannot be filed in any other court. Only one suit we can try. And what are the conditions? The court has inherent powers to stay on conditions of the matter, and the matter must be two suits instituted at different times. The matter in issue in the latter suit should be directly and substantially in issue in the earlier suit. And such suits would be between the same parties. An earlier suit is pending in the same court or other competent court, but not before a foreign court. So these are all the conditions which you have to follow in the case of res sub judice. And when these conditions exist, the latter suit is stayed till the disposal of earlier suit, and the finding of which acts as res judicata on the latter suit. Finality and conclusiveness of judicial decisions for the final determination of disputes is in the general interest of the community, and it's a matter of public policy. Interest of persons should be protected from multiplication of litigation. It's a rule of convenience and not a rule of absolute justice. Then comes the place of suing. The following types of suits in a court within whose local limits of jurisdiction the property is situated. Recovery of immovable property with or without rent or profits. For partition of the immovable property. Foreclosure of sale or redemption in the case of a mortgage or charge. For determination of any other right or interest in immovable property. For compensation for wrongs to immovable property, for the recovery of movable property attached. And property means property situated in India. When immovable property is situated in the jurisdiction of different courts, any court, and when jurisdiction is uncertain, any court, after recording a statement of the uncertainty, where wrong done to the person or to the movable property. Other suits you can file where the defendant resides or where the cause of action arises. Body corporate or company where the sole office or at the place where cause of action arises and where it has a subordinate office. Res judicata means no one shall be twice vexed for the same cause. Rule of Res sub judice means matter pending judicial enquiry. And the doctrine of constructive res judicata that matters or issues which could have been taken as ground of defense or attack in former suit. And it's based on public policy. Then there is a term called a set-off. It's nothing but the reciprocal acquittal of debts between plaintiff and the defendant. And the effect of this set-off is extinguishment of the plaintiff's claim to the extent of the amount claimed by the defendant as a counterclaim. The defendant file a written statement containing the particulars of the debt sought to be set off. Based on this, the court can give a final judgment. Then comes counterclaim. The counterclaim is made by defendant related to some damages or not. Then equitable set-off. Set-off regarding an uncertain amount of money of the defendant is called the equitable set-off. Then comes temporary injunction. The temporary injunction may be asked by the plaintiff when the property in dispute in a suit is in danger of being wasted, damaged, or alienated by any party to the suit or wrongfully sold in execution of a decree, or that the defendant threatens or intends to remove or dispose of his property to defraud his creditors, or that the defendant threatens to dispossess the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in the suit. Plaintiff has to convince the court at the time of getting the injunction that substantial or irreparable harm or injury would be suffered by him if such temporary injunction till the disposal of the suit is not granted, and such loss cannot be compensated by damages. Then interlocutory orders. Power to order interim sale when the movable property is in question and it is perishable in nature. Now comes the institution of a suit. Suit is a civil action, and a suit is started by presenting a plaint in duplicate to the court. And the plaint contains concise statement of material facts of the case on which the party pleading relies on for his claim or defense. And the facts must be proved by an affidavit. And what are the essential? The opposing parties, the cause of action, the subject matter of the suit, and the relief claimed. What is a plaint then? Plaint has a heading and title, the body of the plaint, and the relief claimed. Then there is a term called misjoinder of parties. Two factors are essential to avoid misjoinder of parties. Right to relief must arise out of the same act or transaction brought by the plaintiffs or against the defendants. There is a common question of law or fact. Cause of action is the bundle of essential facts which the plaintiff has to prove in order to sustain his action in a court of law. It's antecedent to the institution of the suit. It consists of a right and an infringement for which relief is claimed. If the plaintiffs are not jointly interested in all the causes of action, there is a misjoinder of the causes of action. Now let us see the stages in the proceedings of a suit. First of all, institution of the suit. Court issues summons to defendant to appear and answer the claim and to file a written statement within 30 days from the date of service of the summons. And when the defendant comes and admits the claim, there is no need of any summons. This 30 days may be extended to 90 days by the court by writing the reasons on record. So extension of 30 days can be given up to 90 days, but the reasons must be recorded by the court. And the defendant may appear himself or by an advocate or pleader, accompanied by some person who can answer all the material questions related to the suit. And every summons must be signed by the judge or an authorized officer of the court and sealed with the seal of the court and accompanied by the copy of the plate. And what is this defense? Written statement of defense by the defendant to be filed on getting the summons. Then comes the appearance of parties. If both parties do not appear when the suit is called on for hearing, the court may dismiss the suit. If the parties are not interested, then there is no point in continuing with the case. That's why this dismissal by the court. And if the defendant only not appear, the court may move ex parte. That means a one-sided order can be given by the court. And when the summons is not served on defendant, the court may order one more summons and postpone the hearing to a fresh date. The defendant may come thereafter and assign a good cause for his previous non-appearance. If plaintiff absent during hearing, the suit is dismissed. An ex parte decree may be set aside by the court when sufficient cause is shown by the defendant. That's also possible. And what are the remedies against an ex parte decree? File an appeal, file an application for review of the judgment, apply for setting aside the decree, suit for setting aside the decree obtained by fraud, and for non-service of summons. Then comes the discovery. Discovery is the finding out of material facts and documents from an adversary to ascertain the nature of the case of the adversary or material facts for the adversary's case. Obtain admissions of the adversary for supporting party's own cause or indirectly by impleading or destroying the adversary's case. Then narrow the points at issue. Avoid expenses and effort in proving the admitted facts. There can be discovery by interrogations also. Interrogations in writing for the examination of the opposite parties. Interrogation means making questions. Not for obtaining discovery of facts exclusively related to evidence of the adversary's case or title. To interrogate confidential communication between adversary and his counsel. To obtain disclosures injurious to public interest. There can be interrogations of a fishing nature. That means questions made in a speculative manner to help the party making interrogations. That means leading questions are asked by which you are getting an answer which is required for you. Then discovery by documents. All the documents relating to the matters in issue in the possession or power of any adversary can be inspected by means of discovery by documents. A party may refuse to produce documents for the reasons where it discloses a party's evidence, when it enjoys a legal professional privilege, when it is injurious to public interest, denial of possession of a document. Then comes admission by parties. One party accepts the case of the other party in whole or in part to be true. Maybe either in pleadings or by answers to interrogations or by agreement of the parties or admission by notice. Then comes issues. Issues arise When a material proposition of fact or law is affirmed by one party and denied by other, issues may be of fact or of law. Issues are framed on material propositions of fact or law gathered from allegations made in the plaint and in the written statement. Allegations made by the parties or persons present on their behalf or their pleaders on oath. Allegations in answer to interrogations. Contents of documents produced by the parties. Statements made by parties or their representatives when examined. From examination of a witness or any documents ordered to be produced. Then hearing of the suit, the plaintiff has a right to begin the hearing. Now let us see what is meant by an affidavit. A written statement of the deponent, the person who is making an affidavit is called a deponent. A written statement of the deponent on oath, duly affirmed before any court or magistrate or any oath commissioner appointed by the court or before the notary public. Used in the following cases. Court may, on its own motion or by an application of any party, order an affidavit. Affidavit of the witness may be read in hearing or he may be examined. Then comes the judgment. Usually a judgment is pronounced by the judge within 30 days of the hearing conclusion. At the most 60 days. The decree is passed in 15 days of the judgment. It contains the number of the suit, names and descriptions of the parties and their registered addresses, particulars of the claim, relief granted or other determination of the suit, amount of the cost incurred and by whom it is to be paid. Then comes execution. Execution is the enforcement of decrees or orders of the court. May be executed either by the court which passed it or by the court to which it is sent for execution. Then comes the right of appeal. And the right is given by statutes. There are many kinds of appeals. Appeal from original decrees. Even from an ex parte decree, we can move for an appeal. Then comes the second appeal to the High Court on a question of law. We have to remember, not on a question of fact, but on a question of law. Then appeal from orders, defect or irregularity in law. Then comes the appeal to the Supreme Court. What is meant by appeal from orders? Order allowing special course. Order for compensation for obtaining attachment or injunction on insufficient ground. Order imposing fine or directing the detention or arrest of any person except execution of a decree. Then appellate order. What about appeals to the Supreme Court? Allowed in certain cases where special leave is granted or from any decree or order of civil court which is certified as fit for appeal. From any judgment, decree or final order passed on appeal by the High Court on appellate jurisdiction. Then from any judgment, decree or final order passed by High Court in exercise of original civil jurisdiction. So these are the areas from which appeals to the Supreme Court can be preferred. Then there is something called a reference to the High Court. Before any judgment is made, any matter may be referred to the High Court for the opinion of the High Court. This term is called a reference. Then comes review. Review happens to the same court which passed the decree or order. When there is discovery of new and important matter by the applicant, and maybe on account of some mistake or error apparent on the face of record or for any other sufficient reason. So the review happens to the same court. Reference is made to the High Court. Then comes revision. High Court called for the records of the case. When the lower court had no jurisdiction, failed to exercise jurisdiction, or acted illegally or with material irregularity, revision petition can be filed in the High Court. Then comes suits by or against a corporation. The company secretary or director or any other principal officer of the company can file. Then minor suits. A guardian appointed by court handles the case in the case of a minor. On attaining majority, he can elect to continue the case or abandon it, resulting in dismissal of the suit. There can be summary procedures also. For the suits upon bill of exchange, hundis, or promissory notes, 1 year of debt becoming due, a suit is